training is on avoiding harassment in the workplace. The training is intended to help you understand what harassment is in the workplace and what to do should you observe it within the workplace. You're going to have a workbook to follow. If you'll turn to your workbook and just open up to the first page, you'll be able to follow along with the slides that we have for you to read. Let's cover what we're going to talk about in today's training. We're going to start by talking about laws against discrimination and harassment. We'll make sure that you understand what they are as we complete the training. And that's how these laws are enforced in the courts. Most companies don't want to take their chances in the courts. You ever been to court? You ever see how that works? When you go to court, do you always get what you want? Not always. So a lot of employers don't want to end up in court, and they found that it's just easier and a better business practice to resolve these things within their own workplace. The EEOC doesn't disagree. They say, you know, if you can resolve it within your own workplace, then we'll support that. But if it comes to us and you can't, then we will make sure the issue gets resolved. So really we get to the point of, now that we have that background of understanding where it comes from, what is discrimination? Really, what constitutes discrimination? So I'm going to ask you to take a moment and write down what you think might constitute discrimination. So, number one, it is harmless to harass someone verbally or to pinch or pat them. Those who object have no sense of humor. When we talk about sexual harassment, do you think that that is a myth or do you think that is a fact? It is a myth. That is correct. When we talk about sexual harassment, pinching and patting really generally isn't acceptable. And this concern that it's just about a sense of humor is exactly the kind of concerns that we have in the workplace, that someone might think that that kind of behavior is okay. Number two, sexual harassment doesn't only affect women, men are victims too. Do you think that is a fact? Or about 15 to 20% of sexual harassment claims actually come from men. Oftentimes men are reluctant to complain or reluctant to say anything because our society really makes it sound like men shouldn't complain about certain kinds of sexual attention or sexual actions. But however, many of the actions that are taken when these are investigated turn out to be that men were sexually harassed in some way within the workplace. But most complaints do come from women about comments or actions that were directed again to them from men. Number three, myth or fact, people invite sexual harassment by the behavior or their dress. In a hostile work environment, it's pervasive, it's repeated, it's a pattern, it goes on all the time. And a lot of times when courts look for pervasive behavior, they look throughout the organization. So they're not just looking at this one incident, but they're looking throughout the organization. That's why companies need to be very careful about monitoring the workplace and looking for places where this behavior occurs and stopping it, because if it's happening over here in one department, and then it's happening over here in another department, and then it's happening over here in another department, that's when we start to look at things that we would consider to be pervasive in an organization. It's allowed everywhere. It's not just something that happened one time, it's allowed everywhere. When the courts see that kind of history, they start to think that this behavior is hostile, it is creating a hostile work environment, because there's really no place for this employee to go. What we do know is that most of the time, an employee dating her boss is signs of trouble. And it could lead to claims of sexual harassment if that particular employee is getting preferential treatment, if that particular employee is involved in a sexual relationship, if as a result of that relationship, there are certain things that are granted to that employee. We could even take it one step further and say, what about the other employees in the department? Are they getting adverse treatment because they're not dating the boss? And then we could even take it one step further and say, is the employee that's dating the boss want to date the boss? Or is she only dating the boss because she doesn't have a choice? And so from there, we just go into this really long, deep, involved conversation. Most companies should have a policy that says that romantic relationships between a boss and their subordinates should not be allowed. And most companies do have those policies. But on the surface, we really don't have enough information to be sure.
One of the things that MEA focuses on is the prevention of problems that spring from workplace harassment, discrimination, and other legal issues. We do this in a variety of ways that conforms with the law. First, you need to have the correct policies, and MEA can obviously provide those, but that's not enough. It used to be enough until the Supreme Court interceded in the late 1990s, but policies themselves don't do it. What has to happen is that employers have an affirmative obligation to train employees, particularly management and executive employees, in respect to those policies. You have to equip them with the knowledge of what they're supposed to do and what they're not supposed to do in conformance with the policies. So prevention is a lot cheaper than cure. It's a lot more efficient than cure. The policies, the procedures that we promulgate, the training that we provide, the complaint procedure, the investigation and the documentation is really one of the most effective means of preventive medicine that there is in employment law.
I want to spend some time focusing just on information that's meant for management. Management has a certain special responsibility when it comes to enforcing harassment laws and enforcing the company policy against harassment. So I want to take